A very good morning to all of you. I, Rishabh Raj, member of Legal Vidya, welcome you all to our ongoing course on contract drafting. I trust that the previous class has been both productive and enlightening. So today is our third class of this course. So I'm eager to delve deeper into the subject matter. Without any further ado, I would like to call Bhumi ma'am to continue the class. Over to you, ma'am.
Yes, hi, good morning, all. So, anyone has any doubt regarding the previous class? Anything they want to ask or any doubt? Any doubt, class? Have anyone attempted
No, ma'am.
draft to draft it? I asked you people to just try and draft clauses and share it with me. I did not receive anything. Anyone wants to share any draft? Okay, so today we'll be discussing about leave and license and lease agreement. So let me just share my screen. Yes. So before we begin, I want to ask, what is leave and license agreement? Anyone has any idea? What is leave and license? Yes.
Ma'am, lease agreement is a form of
I'm
agreement.
asking about leave and license agreement.
Ma'am, lease is done in contracts, whereas license is in easement, I think. And in lease, you have to renew it yearly, year to year, or month to month, depending on the nature. And licenses do not need to be renewed.
Uh, Partly correct. Your first part was right. That yes, license agreements, leave and license agreements are covered under Indian Easements Act, and lease agreements are covered under Transfer of Property Act, not under Indian Contract Act, but Transfer of Property Act. Thereafter, yes, lease agreements are for a longer duration, whereas on the other side, license agreements are for a shorter duration. Let me share my screen. Yes. So, to begin with, here is the definition of lease agreement. A lease agreement is a legal contract that grants the tenant exclusive possession of the property for a predetermined period. It creates tenancy, outlining the rights and responsibilities of both the landlord and the tenant. Now, the duration. This is the most important point in a lease agreement. The duration. The agreement specifies a fixed term, typically ranging from months to year. Now, what is the minimum time period for a lease agreement in India? Anyone has any idea? It's 11 months. So sorry. 11 months. 2 years, which clearly defines starts and the end dates. This provides stability and predictability for both the parties. Now, the other important element of lease agreement is rent. Rent is the remuneration or the consideration we pay in exchange of that accommodation we are living at. So the agreed upon rent amount and the payment schedule are explicitly stated in the agreement, avoiding any future disputes. Thereafter, essential agreement is maintenance. The agreement outlines the responsibilities for repairs and upkeep of the property, specifying which repairs fall under which party. Uh, Suppose if we are having a property So who will look after its denting, painting? Who will look after the electricity? Who will look after the basic cleaning? So usually what happens, landlord is responsible for yearly denting, painting of the property, and the tenant is responsible for the normal wear and tear, right? Lease agreements in India are governed by the Transfer of Property Act, which empowers tenants with legal specific protections, including security of tenure. So, in lease agreement, tenure time period is very important, which gives the security to the tenants that they cannot be thrown out of that property before that period of tenancy expires. Tenants cannot be evicted without the due process, which typically involves providing a valid reason and adhering to the defined notice period. So there's no hard and fast rules that if we are having a 5-year lease agreement, so we cannot ask the tenant to leave before 3 years or 5 years, whatever the term of our agreement is. But for that, we require a proper notice period and a reasoning which needs to be given to the tenant. Thereafter, there is rent control. In areas with rent control regulation, lease agreements help tenants to safeguard against excessive rent hikes. So there are many states which have their own rent control acts or regulations. So these regulations provide kind of safeguard to the tenants so that landlord cannot expect them to pay anything, whatever they are demanding. Then there comes a right to sublet. Now, what is sublet? What do you understand by sublet?
Renting to someone else.
Right. If a tenant rents a property which he has taken from the landlord to some other third party, then that is subletting or sublease. So, in lease agreement, subletting is allowed with the landlord's consent. This is important. We can sublet a property to some other person, but with the landlord's prior consent. Tenants may have the right to sublet the property under certain conditions. Now, here is an example. Suppose Raj signs a lease agreement with Meena. So, this is the same example I gave you for the maintenance thing. Raj signs a lease agreement with Meena, the owner of the flat, for 1 year. The agreement specifies a monthly rent of 25,000 and outlines Meena's responsibility for major repairs like roof leaks, while Raj is responsible for routine maintenance like light bulb replacements. Getting my point? So this was all about lease agreement. Thereafter comes leave and license agreement. So while drafting, we'll see that both these agreements have similar clauses, very slight difference, but still we need to understand what is the basic difference between leave and license and lease agreement, so that while drafting we can every time ensure that we do not draft any such clause which will be in conflict of law. A leave and license agreement permits the licensee. Now, leave and license agreement is between a licensee and the licensor, and whereas the lease agreement is between a lessor and a lessee. Lessor is the landlord who is giving his property on lease, whereas lessee is, on the other hand, is the tenant who is taking the property. Similarly, here the licensor is the owner of the property and the licensee is the one who is taking the property for use. Okay. A leave and license agreement permits the licensee to use a property for a specific period. For a very specific period. Unlike a lease, it doesn't create a tenancy, but rather a revocable permission granted by a licensor. In leave and license agreement, majority of power is with the owner, because owner is not transferring the title of property to the licensee, unlike in lease agreement. In lease agreement, we are transferring the title of property to the tenant or the lessor or the lessee for the duration of the lease. Distinctive features. It has revocable permission. licensor can terminate the agreement with minimal notice, often without needing to provide a reason. So this is in writing. We write usually that we do not need to provide a specific reason, but in contracts, while we are drafting, we always ensure that we include a clause of at least a notice period of 15 days so that other party do not face any problem. So this is what we usually adopt. Then comes no transfer of property rights. The licensee does not acquire any ownership over the property. They are simply granted permission to occupy the space for a defined period. Now, lease and license agreements, these are governed by Indian Easements Act of 1882. Now, compared to the tenants under the lease agreement, licensees have fewer legal protection. Like I have already told you, licensor has more powers as compared to a lessor. They may be subject to eviction with a shorter notice periods or even without a specific reason, depending on the agreement's term. This also we have discussed that in a lease, leave and license agreement, a licensor is not obligated to provide a specific reason, but we always prefer to include a clause of at least some days notice period, at least a 15 days notice period, so that other party do not face any unnecessary hurdles or unnecessary prejudices caused to the other party. Now here is an example. Shweta needs a place to stay for few months while she renovates her home. Now in this case, what is preferable? What is preferable according to you? Anyone? If Shweta wants a place to live in while her original or her own home is under renovation, what is preferable to enter into? Lease or a leave and license agreement?
Leave and license agreement.
Mom, leave and license agreement.
Yes, that's right. Because that is for a very short duration. That can be for a short duration, not like a lease agreement, which should be at least for 11 months. So she enters into a leave and license agreement with Daksh, the owner of the guest house. The agreement allows her to occupy a room for 3 months, with Daksh retaining the right to terminate the agreement with 1 month notice. Getting my point? Now, this we have already discussed how to choose the right agreement. If we are looking for a place to run our business for a shorter duration, or if we are looking for a place to run our business for a long duration, so accordingly we can choose. If we are looking for a place for a longer duration, we can go for a lease agreement, and if we are looking for a place for a shorter duration, then we can always go for a leave and license agreement. Then there are two types of leave and license, both commercial and non-commercial. Commercial leave and license and lease agreements are the agreements in which the lessor or the licensor enters into an agreement with the lessee or the licensee for some business purpose, for commercial office spaces. On the other hand, there can be non-commercial as well, when one is looking for an accommodation or for a lease or a license for their residential purposes. Getting my point? So this can be both commercial as well as non-commercial. Yes. So we have already discussed that there can be two types of leave and license and lease agreements, both commercial as well as non-commercial. Commercial, when we are taking a property for commercial purposes, like for running shops. And on the other hand, if we are taking a property for a personal use, like for a residential purpose, then that is called a non-commercial lease agreement and a non-commercial leave and license agreement. Then we have already discussed this, that the key considerations of a leave and license agreement are the time duration and the control and the flexibility. In leave and license agreement, landlords have a greater control over the property and they have more ability and power to terminate the agreement. Whereas on the other hand, lease agreement, both the tenant and the landlord has this almost same powers to terminate the agreement and the control over the property. Any doubts? Otherwise, we'll move on to the drafting part. Any doubt?
Hello, ma'am. How is it different from rental agreement, lease agreement, rental agreement? And second is
Rental, yes, yes, yes.
why did you keep 11-month minimum tenure for lease? Is there any reason?
So basically, the major difference between the rent agreement and a lease agreement is rent agreement is as per the rental regulations of each state. Each state has their different rules, regulations as per which a rent agreement goes on. Basically, a rent agreement and a lease agreement have the same terms and clauses. So while drafting, we can have the same terms and clauses. All we have to ensure is that the rent agreement complies with all the state regulations. On the other hand, lease agreements is governed by the Transfer of Property Act. So it does not run as per the particular regulations of the state. Getting my point? And then
Yes.
duration part comes from the regulations. Longer duration is so in rent agreement we have this clause of 11 months. Similarly, in lease agreement also, we prefer taking, this is not a hard and fast rule of 11 months, but in lease agreements as well, we prefer taking 11 months so that it does not conflict with any state's rental agreement. Getting my point?
Okay.
Yes. So now we'll move on to the drafting part.
Ma'am, one question.
Yes.
Ma'am, what is the minimum or maximum period for license agreement?
There is no minimum maximum period. If we are entering into an agreement, of course, we'll not enter for 15 days, right? So if we are signing an agreement, it will be at least for 3 months, 5 months. But there is no minimum and maximum duration for leave and license agreements. It is for a shorter duration. That's it.
Okay, ma'am.
Yes. So in the last date, as I was unable to complete the draft, so today I have this draft with me, which I have drafted. So now we can go on to each clause, discuss each clause, and you guys can give your own clauses, which I'll incorporate here and try to modify a bit. So we start with the introductory part. Execution date. The leave and license agreement are governed by Indian easement part. So this is the introduction. Then comes the execution part. The leave and license agreement is signed and executed on so and so date at so and so place by and between so and so parties. So first party will come as licensee and the other party will come as licensor. Licensor will be a person who is giving his or her property to the licensee. Now the first clause which is important here is the grant of lease, where this is kind of purpose clause, that for what purpose are we granting this license, and it will also include the term of the agreement, right? The licensor hereby grants leave and license to occupy and use this 1 BHK flat in XYZ apartment near so and so place. So this is the description of the premises for a period of, here I have written 11 months, but it can be any period, shorter also, 6 months as well. From so and so date, which will be the term of the agreement. The licensor hereby clearly states that this agreement provides only for the leave and license and no tenancy rights of any kind shall be granted in any case. This is an important clause to clarify that you have a very restrictive right only pertaining to the leave and license, and no tenancy rights will be given to you. You will not be a tenant and you cannot have the title transferred in your name. Right? Then comes the payment clause. The licensee shall pay the licensor a sum of so and so rupees per month calculated at so and so price as a licensee fee or compensation. So in lease agreement, we have rent, and in license agreement, we have fee.
Excuse me, ma'am.
Yes.
Ma'am, here in the recital, why are we not mentioning anything about the licensor?
About the
Licensor.
we can. The licensees are MBBS students who needs to intern at so and so place for the purpose of his practical experience, as he is not the native residents of Karnataka, and so in order to complete his internship he wants to shift to Bangalore, right? So this gives you a background that why we want to take this property for a short duration. This gives you a picture that this has to be a license agreement for the reason that this is for a short duration. Then he has decided to avail 1 BHK flat at Bangalore, which is located near to his internship destination on leave and license. In pursuant to the same, he approached. Now, I drafted this as a drafts person. Suppose a person has approached me to draft a leave and license agreement, so I am drafting this on his behalf, and I do not know much about the licensor. But in case you already know about the licensor, you have the details, you can definitely include those details in this. So I'll include those. In person, he approached the licensor to acquire his 1 BHK flat located at so and so place for the period of his internship. The licensor, who is the owner of the so and so property, you can define this term as well, has agreed to enter into this agreement on the below mentioned terms and conditions. Now it's fine. Or you can have, he has approached Mr. XYZ ABC. The owner of the flat to acquire his 1 BHK flat located at so and so for the period of the licensor. We have already defined it as licensor, so we'll use the term licensor only. Fine. Now it's fine.
Yes, ma'am.
And from here, I am removing the word property because we have defined it as premises below. So we have to be a little particular about the terms we are defining, because the term which is defined once, which will be used every time in all the clauses. Then comes the payment clause. Now, give me a payment clause. I want you guys to draft a payment clause. We have already drafted this for distributorship agreement. So you know how to draft a payment clause. Give me some ideas of payment clause. Yes. Mithilesh has raised his hand. Yes, Mithilesh, you want to ask anything?
I have asked, ma'am. I have raised earlier.
Okay, okay. Anyone? I'm waiting for your answers in chat box. Guys, give me the payment clause. Please, at least attempt something. The licensee has agreed to pay a sum of dash to the licensor at the beginning of the term. Okay. Ratnesh has given me a clause. Let me write down. Anyone else? There are total 20 students, 2022, but only one is attempting. Mithilesh, the monthly payment of rupees 10,000 would be paid every month at the first week. Yes, nice attempt, Mithilesh. Anyone else? I'll jot it down this as well. Animesh, the licensee shall pay an amount of rupees itna per month for the duration of whole term and shall also deposit itna before the starting of the term. The license. Okay. So now let's discuss all the three clauses. Okay. The licensee has agreed to pay a sum of rupees dash to the licensor at the beginning of the term. Now, we always prefer to have per month clause, monthly clause in leave as well as in license agreement. So at the beginning of the term does not suffices our purpose, because then we have not defined what will happen thereafter. What will be the payment clause thereafter? At the beginning, suppose the licensee have given 1 month's rent, then thereafter what will be the clause? So this can be, the licensee has agreed to pay a sum of rupees dash to the licensor. This sum shall, or this, we can define this term as licensee fee or the license fee. This sum shall be paid by the licensee to the licensor on or before 7th day of each calendar month. Getting my point? This sum shall be paid. Licensee has agreed to pay rupees itna to the licensor per month till the term of the agreement. Better? Whose clause was this? Ratnesh, right? Am I audible, guys?
Yes, ma'am.
Yes. Okay, Paras, Bhavya, I'll discuss all these clauses later. The monthly payment of rupees 10,000 will be paid every month at the first week, by the first week, or it's better to specify by the first week of the month. This is okay. Then the licensee shall pay an amount of rupees 15,000 per month for the duration of the whole term, and shall also pay a deposit of 5,000 before the starting of the term to the licensor. Now it's better if we define this as an advance, or we can say as a security deposit. Okay. Now let's go on to the other clauses. Licensee shall pay the licensor a non-refundable license fee of this payable upon the execution of this. Okay. So Bhavya, what Bhavya has given is the clause which can be used in a very specific type of agreements where a licensor and a licensee have agreed to enter into this agreement for a very fixed duration, and they are taking this payment as a one time. So suppose A enters into an agreement with B for 3 months on the consideration of rupees 2,500 per month. So then in this case, the licensee shall pay the licensor a non-refundable license fee of 75,000 payable upon the execution of the agreement. So this is one-time payment which she's talking about. So one-time payment done. Now the licensor and now the licensee is having no obligation to pay further till the 3 months, and upon the completion of this 3 months, this agreement will automatically terminate and the licensee will be obliged to leave the property. Right? Then Parasbal, in consideration of the grant of the license to use the said premises as a faucet, the licensee shall pay the licensor a license fee at the rate of rupees itna per month commencing from this day, payable on or before 10th day. Yes, this is a good clause. I guess this does not require any modification as well. This is a good clause. Then Roshni Pandey, licensees have to pay the amount of rupees this before 15th of every month, and 1 month of rent will be submitted as security. we'll not use the word rent over here. It's better to use 1 month of license fee will be deposited as security. Yes. If the license fails to pay the amount or right time, the licensor may charge a late payment fee of it. Yes, correct. That's right, Lakshmi. So now let's go on to what I have drafted. The licensee shall pay the licensor a sum of rupees 4,000 per month, calculated at the rate of rupees 10 per square feet as a license fee or compensation, which I have defined as a license fee, to be paid in advance for each month on or before the 10th day of each English calendar month. Now, license agreement, this was for referral. The licensee shall pay the license fee through so and so bank. So we have to be as comprehensive as possible while drafting any contract. So we'll include everything, that what will be the transaction mode, what will happen in the case of late payment. So all this needs to be included. So I've included this clause: the licensee shall pay the license fee to the licensor through the bank transfer on the given below bank details. Now here, as per your client's convenience, you can use either through bank transfer or in cash if they want the payment to be in cash, or through RTGS, NEFT, any mode. You can include so and so on so and so account number at so and so place and branch and everything. Then the licensor hereby clearly states that the licensee shall be liable to pay an additional sum of rupees 50 for each delayed day from the 11th day of each calendar month as a penalty. Getting my point? So here is the clause for delay payments. If in case you delay the payment, then this will be the penalty you will be obliged to give to the licensor. Then I have defined the security deposit in a separate clause, which you guys have drafted in the same clause. So there is no rule that to have a separate clause. You just need to be comprehensive with the terms. I have included this in a separate clause. Let's go through it. The parties hereby agree that the licensee shall pay the license fee of 2 months amounting to rupees so and so in advance on the execution date as a security deposit along with 1 month advance license fee. The licensor is hereby bound to return this security deposit amount on the date of expiration of the term of this agreement. If any of the events mentioned in clause 6, now for that I'll have to go to clause 6. In any of the events mentioned in clause 6 of the agreement occurs which leads to the termination of this agreement prior to the date of expiration of the term, then the licensee shall be under an obligation to inform or notify the licensor in order to demand the return of this security deposit within 10 days of such termination. The notice shall be provided via email on the given email ID so and so. Getting my point? This is a very comprehensive draft which I'm sharing with you. It includes everything: the mode of transfer, in which all cases licensee will be obliged to get the refund of the security deposit, and what can be the cases in which the licensor will not be obliged to give the security back to the licensee. Right? Any doubt? Anything you want to discuss? No? I take that as no. I'm moving on to the next clause. Just see. In case of failure of legal vidya, in case of failure of licensee to make payments for more than XYZ from the date of due rent of rent payment, then the licensee shall be liable to pay a penal interest on the due amount till the date of Yes, right. Here we can include this till the date of actual realization of the license fee along with the applicable penalty. Okay, let's move on to the next clause. Next clause is
Ma'am,
maintained. Yes.
sorry, ma'am. I believe that we are missing one point in the payment clause
Yes.
related to increasing or adjustment of the annual review or annual fees. The licensor reserves the right to review and adjust the rent and license fee annually, or any
So
increase shall be
yes, you
communicated
are
to the
right. You are right. So
yeah.
that clause is usually incorporated in a lease agreement and not in a leave and license agreement.
Okay.
Because
Okay.
leave and license agreement is usually for a shorter duration. Here we have included 6 months. You cannot expect someone to increase the amount in the duration of 6 months.
Okay. And what about the taxes and other fees in case it will be there?
That will cover.
Yeah.
Yes, that will be covered.
Okay. So the licensee will be responsible for the paying all the taxes and levises and
Licensor will be responsible because he is not transferring the title of property to a licensee,
okay.
right?
But
So
if we are
licensor will be responsible for the taxes and all.
okay, but if we are agreeing, if we are making an agreement and we put a clause in that licensee will be pay all the applicable taxes and levises and fees arising out of in connection with this agreement, then
Mhm. Then that will be in conflict.
that will be in conflict. Okay, then
Yes.
okay.
Because here in leave and license agreements, we we are not transferring. We matlab, the
Uh,
licensor is not transferring the title of the property,
okay,
so the licensee will not be obliged to pay the taxes.
okay. Okay.
Yes.
So it will be a conflict of law if we
Yes.
are making okay, no.
Yes.
Okay.
6 months from, just let me correct this, June to December. Okay. So now comes maintenance clause. The licensee shall maintain the premises in good condition and will not cause any damage thereto. If any damage is caused to the premises or any part thereof by the licensee, the same will be made good by the licensee at the cost of the licensee, either by rectifying the damage or by paying cash compensation as may be determined by the licensor's architect. The licensee shall not carry out any work or structural repairs or additions, alterations, or any kind of modifications in the premises. Only such alterations or modifications are permitted in the structural type or permanent nature as may be allowed by the licensor. Getting my point? All other maintenance charges shall be paid by the licensor and licensee shall not pay any such maintenance charges. Any doubt in this? Or you have any suggestions? You want to draft it in any other way? Yes? Yes? Give me something.
Ma'am, what if like it is already damaged, like some part of the building is already damaged,
Mhm.
but the licensee does not see it before taking it into his or her like taking it into, what do we say? I forgot the term.
Before
Oh.
entering into the agreement.
Yeah, right. So then what do we do? That's not the licensee's fault, right?
Yes, that's not the licensee's fault, but if licensee was permitted to come and inspect the building before they entered into an agreement, right?
Oh,
So
yeah.
that is not even the licensor's fault, and the licensee has no right to claim it further.
Ma'am, but what if the damage is not apparent, but later on, like maybe something like water leak from the walls,
Okay.
like while the licensee was inspecting, that was not there, but as the building starts aging,
So basically, this is a matter of dispute. Here, disputes arise. But if you want to be very clear, very specific, if suppose you are drafting this agreement on behalf of the licensee, right? So you
yeah.
can always have a clause in this, like the parties do hereby agree that the licensee shall not be liable for any of the damages or defects which exist in the premises prior to the execution of this agreement, and the licensor shall be obligated to have these pre-existing defects or damages be rectified within a period of 7 days from the date of intimation of such defects by the licensee. Just a second. Have the pre-existing defects divided from the date rectified at his own cost. Getting my point?
Yes, ma'am, got it.
So that depends on whose behalf you are drafting an agreement, or on whose behalf you are vetting an agreement. So while vetting an agreement, you always have to see one thing, that you prefer your party's interest over the other party's interest. If you are suppose drafting this agreement for a licensee, you will definitely incorporate those things which are favorable for a licensee. And if you are drafting this agreement on behalf of a licensor, then you will never include this clause. You will never include this clause. Instead, you will modify this clause in a way. I'll write that as well. The parties do hereby agree that the licensor shall not be liable for any repair or replacement of any pre-existing faults, damages, which are not for any pre-existing faults or damages after the execution of this agreement, and it is the duty of the licensee to have the premises inspected properly before entering into this agreement. Getting my point? So now,
Yes.
if we are drafting this clause on behalf of the licensors, then we'll include a clause like this, that if there are any pre-existing faults or damages in the premises, it is the licensee's duty to have it properly inspected before entering into this agreement, and you cannot thereafter come after like a week or 10 days and say that this was the fault and you are now obligated to repair this. Then that will be licensee's fault, that he has not inspected the property properly before entering into this agreement, and now he has to get it repaired or modified or anything from at its own cost. Okay. Now the other clause is permitted use. This is a very
Ma'am,
yes.
ma'am, can we not add one clause? If you are writing from the license's point of view, can we not add that the licensee should take a fire insurance or the insurance for the property of from this particular firm for this particular money till the duration of the license?
Licensee.
Yes, ma'am. Licensor I mean, asking licensee to take a fire insurance or
No. In leave and license agreement, we do not require. Again, because of the reason that this is for a shorter duration. If we are entering into a leave and license agreement for a longer duration, suppose we are converting this leave and license agreement into a lease agreement, then we'll definitely have the insurance, and that insurance will be taken by the licensor and not the licensee. Okay.
yes, ma'am.
Yes, because here the ownership is with licensor, so licensee does not require to take insurance for that property. It is the licensor who needs an insurance for the property.
Then, ma'am, what will happen to the damage that is caused to the property during the period of that license, but it is not due to the fault or negligence of both the parties?
That will come on the licensor, because
Okay.
ownership, if it is not because of the fault of the parties and due to some unfortunate event, then that will come on the shoulders of the licensor and not the licensee, because he is the one who is having the ownership of that property.
Ma'am, I believe
Okay,
that
ma'am.
Ma'am, I believe that nowadays the licensor and licensee both are taking the pictures and putting as a supporting evidence in their agreement for verifying means to give them as an evidence that they did the damage or not.
Yes, this can be done. Usually people do, because now everything is digitalized, so people do prefer to take pictures that, see, this is the condition in which you are transferring your property to me, and so I'll not be obliged to get these defects which already exist be repaired at the end of this agreement, right? So shall we move forward?
Yes, ma'am.
Okay. Permitted
Yes,
use.
ma'am.
The premises shall be used only for the living and personal use and no other purpose. So this is a non-commercial leave and license agreement. So we are very specifically stating that this premises should be used only for living and personal use and no other purpose. It is not a case where you can use the premises for any commercial thing or for any illegal purpose. The premises are given to the licensee on personal basis, and the licensee shall not be entitled to transfer the benefit of this agreement to anybody else, or shall not be entitled to allow anybody else to occupy the premises or any part thereof. Nothing is in this agreement shall be deemed to grant a lease, and the licensee agrees and undertakes that no such contention shall be taken up by the licensee at any point of time. The licensee shall not be deemed to have in the exclusive right over the premises, and the licensor will have the right to enter the premises at any time during the day hours to permit the inspection of the premises. If the licensee breaks any of these non-permitted uses, the licensor shall be at a discretion to terminate this agreement immediately without a notice. Any doubt in this clause? Anything you want me to explain? Overall, this clause provides all the terms for which purpose you can use this property, what are the restrictive things. Also, it provides you a very clear term that the licensor is allowed to inspect the property at any time during the day's hours. Then the licensor is the exclusive owner of the property. He has exclusive right over the property, and this leave and license agreement should not be taken apart with the lease agreement. Okay. Any doubt, or should I move forward?
No, ma'am.
Okay. Then comes the termination clause. Apart from the expiration of the term of this agreement can be terminated in such events of default occur or take place. Now, this is a termination clause where we'll lay down the circumstances in which this termination can take place even before the expiry of the term. So we have this leave and license agreement for a term of 6 months. If in case these events happen, then we can terminate this agreement even before the expiry of the 6 months. If the licensee is found misusing the premises or doing any illegal act on the said premises. Other is if the licensee delays the payment of the license fee along with the penalty for beyond 2 months. If the licensee is found involved in any criminal act or any criminal proceedings are found commenced against him. If the licensee damages the licensor's premises and denies to pay the compensation for the same. If the licensee causes any nuisance or annoyance to the people living in neighborhood, if the licensee breaches the permitted use clause mentioned above. Then comes the licensee can terminate this agreement if the licensor commits any of the breaches of this of his obligation as mentioned in so and so clause. Now, if we are drafting this agreement from the perspective of a licensee, as we have included here, right? And if the licensor is not complying with the terms as mentioned in so and so clauses, which we will be incorporating in case we are drafting this agreement from the perspective of a licensee, then in case of those events, licensee will also have a right to terminate this clause. But as this is a leave and license agreement, this will be only after providing a notice period. Licensee cannot terminate this agreement immediately, right? In any of the aforementioned conditions, it is mandatory for a party terminating the agreement to give at least 10 days prior notice to the other party, notifying the same to the other party. Getting it? Any doubt? Any doubt, class?
No, ma'am.
Okay. Now comes
Ma'am.
the point. Yes.
When we are putting on the above clause that immediately we would terminate in the while we access in the restricted area.
Right.
Okay, and then in the termination clause, which is a main, it is mainly related to termination. Then why we would not means in the means put over here?
Yes, this is rightly been noticed by you. So we'll remove this.
Yes.
Shall at the discretion terminate this agreement with a prior notice of 10 days. Or we can do one thing, if we are including that above, that we do not want to provide a notice, and there will be an immediate termination if the licensee is found using the premises for any of the reasons, for any of the purposes which is not permitted, then we can have a clause here without that in case the licensee is found or if the licensee remove this, if the licensee breaches the permitted use clause mentioned here, then in that case the licensor shall have or may have the right to terminate this agreement immediately without any notice, and in the above mentioned cases, in as mentioned in clause 6.1, it is mandatory for a party. However, if any event as, so we'll define this as well, 6.3. I can make this as 6.3. This will be 6.4. In any case, in any of the cases as mentioned in clause this, it is mandatory for a party terminating this just a second clause. I'm including this clause in bracket or to the other party notifying the same. However, in case any event as mentioned under clause 6.3 occurs, then in such case the licensor will not be obligated to serve a notice period to the licensee. Fine.
Ma'am, for the termination clause and the above clause as well, so it depends for which party we are making the agreement,
Drafting
right?
right.
So for the, if we are doing it for the licensee, then we can put a term like there should be a minimum notice period of at least like 15 days or 1 month, and for the licensor, like we can say that it should be terminated immediately or something. Okay, got it.
No. So just have this very clear. We cannot write anything which is against the law. We have to give rights to the licensor either at
Okay.
par with the licensee or above to the licensee. Because in leave and license agreement, licensor has the ownership and control over the property. We cannot make or write such a clause where the licensee is given more power than a licensor.
But ma'am, when we are drafting, so if the licensor says that it should be effective immediately, like the termination or something, then it is like it is an injustice towards the licensee, right? I mean, if that person
No,
does
no.
not have anywhere else,
No,
if that
why
person does
will it
not have
be
any,
injustice? He is the one who is breaching the agreement by using the property for something which is not permitted, right?
yes, but if he is meant to made to leave the space immediately, then he can't go somewhere else immediately, right?
Suppose,
He need to
just
find a
suppose
place.
I gave my property to you, right? I
Yes, ma'am.
came and inspected the property. I found a dead body over there, right? Will I not
Okay.
ask you to leave my property immediately, or will I serve a notice period to you?
Right, right. Got it.
Right?
Got
So
it. Got
it
it.
depends
Yes.
on the facts and circumstances, and if you are exclusively, if it's mentioned here exclusively that you can use this building only for living and personal use, right?
Yes,
And
ma'am.
you cannot use this property or indulge into any illegal act, then in such cases, definitely if I'll find you doing any of these things, I'll ask you to immediately leave my property.
Right. Got it.
Yes. So that depends on the facts and circumstances, definitely. That's why even after we enter into an agreement, there is always a chance of dispute and we go into the arbitration, right? And we
Yes,
as a
ma'am.
lawyers, now this is something hilarious, but we as a lawyers always wants disputes because that's the source of income for us. So yes, this is it. Any other doubt?
No, ma'am.
Okay. However, if in case the okay, discretion to terminate this agreement, now I can write immediately without any notice period. Then comes the consequences of termination. What will happen with the payment and what will happen with the security deposit in case of termination prior to the expiration of the term? On the
But
expiration, yes.
we can put with and without means immediate effect without
Yes.
notice. With and without,
Yes.
it will be clear.
Yes, we can go either with or without.
With and without, yes.
Sorry?
Yeah, ma'am. The same thing. With and
Yes,
without.
that's why I have included the word may over here. If you can see, the licensor will, where do I? If the licensee breaches the permitted use clause mentioned above, then in that case, the licensor may, right? It is not obligatory. If we want, if the non-permitted use or if the licensee is found doing something which is not that serious, then we may serve him a notice period that look, I'm giving you a notice period of a month or 10 days or a week. Just look for some other accommodation for yourself and I'll come on so and so date. I want my premises be vacated by then. And if we find anything which is very serious and we cannot tolerate it, then we can definitely serve him, then we can definitely ask him to immediately vacate the property without even serving him any notice period. Okay? So that will depend on the facts and circumstances of the case.
Ma'am, I had a question. So, above we have mentioned that for living and personal use, there are circumstances where people live in that place, and
Mhm.
let's say a lady is living and she is doing sari business there,
Mhm.
and she gets customer to her home and shows saris and all. So will that not be considered as doing business and
Yes,
not
definitely. That will be commercial. That will be using your property for commercial purpose, because she'll definitely maintain a stock over there.
right? So in that case, the agreement will be terminated, right? Because
Yes,
she is
in
going
that
beyond.
case, if yes,
So she is going beyond what's written in the clause, and
right,
she's it.
right. Then in that case, the licensor may serve her a notice period and ask her to vacate the property in so and so date.
Got it. Got it.
Now we are running beyond time. Let me just complete this. Then on the next class, we'll take the lease agreement on the next class. Consequences of termination. On the expiration of the term of this agreement, the license or the earlier termination thereof, the licensee shall, within a period of 10 days, hand over the vacant and peaceful possession of the premises to the licensor. In the same condition, in which the premises now exist, subject to normal wear and tear. The licensor shall return the security deposit amount within 10 days of the termination of the agreement. This amount shall be returned by so and so bank transfer to the licensee's bank account. And here are the details of that. If the licensor does not return the security deposit amount within the given time period, then the licensee shall have the right to remain in the premises till the complete security is returned to him. If in case the termination takes place due to the events mentioned in clause so and so or so and so, the licensor shall have the right to retain the amount of security deposit till the same default has been completely made up by the licensee. Any doubt? Any doubt? So basically this clause includes that the licensee will be obligated to transfer the property to the licensor in the same condition as he has transferred it to the licensee, subject to normal wear and tear. Then what will happen with the security deposit? Once the termination happens, then the licensor will be obliged to return the security deposit to the licensee on so and so bank account in so and so dates. If he does not do so, then the licensee will have the right to remain there in the premises or use the premises till the complete security deposit is returned to him. And then in case termination is due to the delay in fees or due to the nuisance caused or due to the damage in the property, then in that case the to retain the amount of security deposit till the time such default is made up by the licensee. Okay. So now there can be, I have not included the boilerplate clauses in this because we have already discussed those in the distribution agreement. Boilerplate clauses are almost same in every other agreement. If you want, we'll have a separate class for that boilerplate clauses so that we can discuss each clause of the boilerplate in detail. Now here is again a difference between lease and license and leave and license and the lease agreement. You can go through this, and then on the next class we'll discuss, just a minute. On the next class we'll discuss about the residential lease agreement and the commercial lease agreement both. Okay. So I'll be sharing this document with Sakshi and she can share this with you guys on the group. Yes. Now let me know if you have any doubt, please. The
Ma'am,
license. Yes.
Yeah, do we need to register this lease and license in registrar or for
Yes, yes,
enforcing?
definitely.
Yeah,
There'll
and
be a registration of this
yeah,
agreement.
but and if we not registered in the registrar, then it will be not enforceable in the court, right? Or it will
Yes.
be considered as a document or a proof of supporting document only.
No, it's always preferable to have the document registered.
Yeah, okay, okay.
But as this is for a very short duration, you can opt not to register it
Yeah, yeah, that's
and
fine.
buy a stamp paper
Correct.
instead of a registration. You can buy a stamp paper, but in case you are entering into a lease agreement, it's always preferable to have it registered.
Okay, okay. On the stamp paper, it will be enforceable in the court, or just putting on the affidavits.
No, no, you need a stamp paper.
Okay, okay.
Any other doubt?
Ma'am, I have a question.
Mhm.
Ma'am, can you have multiple licensee in one license agreement?
Yes, definitely. Why not? But that has to be consensus with every licensee. There has to be
So
a consensus.
would you have different whereas clauses and permitted use clauses for all different licensee, or they would be same?
Suppose you are having a apartment which has 5 different flats, rooms, right? And you want to give each flat to a different licensee, and if they have no problem in sharing one agreement and you want to bind them with the same terms and conditions, then in that case you can have a one license agreement, and you can accordingly modify the clause for each licensee. Suppose you are defining the premises, then you will have a different clause. Suppose XYZ person is given the premises having description so and so, then other ABC person is given the premises having description so and so. XYZ person will live on the premises for so and so period. ABC person will be using the premises for so and so time period. So like this. But that there has to be a consensus.
And ma'am, can you sublet your license?
No, subletting license is usually not permitted in shorter durations, but if you are converting this into a longer duration agreement, then you can definitely provide a sub licensee, but that will be completely upon the discretion of the owner. Usually, it is not into the practice because once you are going into a longer duration agreement, that converts into a lease agreement.
Okay, thank you, ma'am.
Okay. Any other doubt? Any other doubt regarding last class distribution agreement? Also, if you want me to take up any specific agreement, you can let me know. I can do that as well in the next class.
Ma'am, if I mean, I'll draft a agreement. Like, where do I send that? I don't have your contact
You
details.
can send me, I'll share my contact number. So this is my contact number. Also, I'll share my email address so you can send me on my email as well. And if you are dropping me your agreement over the mail, just drop me a text as well. Okay.
Okay, ma'am.
Also, I'd suggest, how many of you are on LinkedIn? Are you guys using LinkedIn? Have you made your profiles on LinkedIn?
Yes, ma'am. I'm using that. I'm there.
Yes. So, in order to make your profile strong, I'd suggest draft an agreement. We have discussed 2 types of agreement: distribution and leave and license. And you have a bit of idea about lease agreement as well, right? So you can draft a very short agreement and share that on LinkedIn. Post that on LinkedIn. You can write 4 or 5 lines about that agreement, explain what lease and license agreement, what leave and license agreement is, or what a distribution agreement is, and post your draft on LinkedIn. And you can even tag Legal Vidya or me in that agreement, in that post, if you want to get more and more views. So this will definitely increase your viewers, and you may get something good.
Sure, ma'am, I will do.
Yes. Okay. So we'll call it a day today, and we'll see you guys on next. Thank you.
Thank you so much, ma'am, for this class. I hope everyone learned how to draft license agreement, and we'll see you in next class. Thank you, ma'am.
Thank
Thank you for joining, everyone.
Thank you, ma'am.
you.